We trust PMT because we know they're professionals. We've been working with PMT for over 20 years.
They're the most customer friendly, they're the most timely, the most accurate.
They are really wonderful with their technology and the advancements of their technologies that they implement.
They treat us like we're the only client that they have.
Whatever we need, we know it's going to get done. So that's really important to us, that personal connection.
Pacific Media Technologies. Technology driven, quality guaranteed.
So thank you again to Pacific Media Technologies for their support. We appreciate it. I am Thomas Haire. I'm the Chief Content Officer of the Performance Driven Marketing Institute. And we have with us today 3 attorneys who are part of our PDMI Government Affairs Council. We're very lucky to have them here today and give them a brief introduction before we get to the questions. Now, we're happy to welcome all the way to the right of me, Roger Colaizzi. Roger is replacing Shaheen Rothermel, who was unable to make it out here today. But Roger is her colleague and is a longtime leader in the space. He chairs Venable's National Advertising Litigation Group, has significant trial experience litigating a number of different areas of advertising and performance marketing law, including Lanham Act false advertising, state deceptive trade practices, unfair competition, social networking, affiliate advertising, and other e-commerce matters. He's represented clients before agencies like the Federal Trade Commission and the Consumer Financial Protection Bureau, and self-regulating bodies like the National Advertising Division of the Better Business Bureau. Roger, welcome, and thank you for stepping in. We appreciate it.
Happy to be here.
Absolutely. In the center, we have Damon Wright, who heads the advertising and e-commerce practice at Gordon Rees, LLP. Gordon Rees, thank you for joining. You're one of our newest PDMI members. We appreciate that. Damon represents leading brands, direct response advertisers, e-commerce retailers, lead generators, advertising agencies, fulfillment companies, technology companies, and related service providers. His clients span almost all verticals and is relied upon as a trusted advisor on advertising, regulatory compliance, intellectual property, and more. He's a determined advocate when litigating FTC and state attorney general actions, business disputes, consumer class actions, and more. And he's also the editor of E-Commerce Legal Guide, a practical playbook for any online advertiser. So thank you, Damon. Appreciate you being here.
My pleasure.
And directly next to me is Daniel Kaufman. He's a partner in the Washington, D.C. office of BakerHostetler and brings nearly 25 years of experience with the Federal Trade Commission's Bureau of Consumer Protection, recently leading the 450-person bureau as acting director, where he oversaw all protection matters, including investigations and cases involving privacy, data security, advertising, influencers, endorsers, and other marketing practices. As deputy director of the bureau for most of the past 10 years, he was involved in virtually every high-profile consumer protection and privacy case brought by the FTC during that time. We welcome you, Daniel. Thank you for joining us. Absolutely, absolutely. You know, the FTC did not take the summer off, as many of you probably know. In recent months, the commission offered comment periods to the industry on planned changes to a number of its rules, including the .com disclosures, which are the digital advertising regulations, which were originally put out about 9 years ago, I believe, or most recently updated 9 years ago. The PDMI's Government Affairs Council took the lead, and with the help of Daniel and some others, put together a public comment from the PDMI, which was a fantastic thing for us to be involved in. We're keeping a close eye on that and other regulatory matters. So we're excited to keep working on members' behalves here. And the first thing we can do here today to keep doing that is ask some questions. So Daniel, I'm going to start with you. We had our last in-person panel in March. We've also had a couple of webinars in the meantime. But have there been any changes in the overall tenor of the FTC with respect to the performance and direct-to-consumer industry in the past 7 months?
Short answer, yes, but I will say more than that. You know, it's interesting. I think for the first year of the sort of Lena Khan administration, we were sort of hearing the signals, but we weren't quite seeing everything play out. I think now we are having a lot more visibility into what is the new FTC, what are they doing, what are their priorities. They've kicked off, maybe we'll talk about this a little more, 6 different rulemakings, which is sort of unprecedented since the 1970s, and looking at sort of what they're focusing on. They just started a rulemaking last week on what they're calling, it's a lovely term, junk fees, but they want to regulate any fees that are sort of, don't add much value to consumers that are being tacked on in purchases. They want, you know, when you go to the register, the advertising price is what you pay. So that is a really big deal. And but we're seeing, you know, there's really a big focus on on disclosures, how information is being presented to consumers, on subscription services, on dark patterns, on how data is being used to advertise. And they're getting aggressive in all these fronts, whether it's through rulemakings, through policy statements, through broader interpretations of existing laws. So we're definitely seeing sort of the setup has happened, and now we're seeing a lot more follow-up through rulemaking and all these other policy devices. So I think it's going to be an interesting next year to see, where things land. And a lot of this originates. I know we've talked a lot about the AMG case from last year, and that dramatically reduced the ability of the FTC to get money in federal court. And they are sort of doing a lot to compensate for that. A lot of things they're doing are arguably going beyond the statutes that they enforce, but we're seeing them using all the tools that exist in the toolbox and then some.
Mm-hmm. Damon, anything to add there?
I agree completely with everything Daniel said. You would have thought perhaps after AMG Capital, a 9-0 loss for the FTC, it's incredible to have the Supreme Court agree 9-0 on anything, that the FTC may have come away humbled and maybe more measured, but actually they had just the opposite reaction, which was kind of angry, and we're not knocked down, we're coming back stronger and more fierce than ever. So that is shown through the very creative interpretation of the subscription billing law, ROSCA, to try to make it into an advertising statute, kind of like a substitute for Section 5 if a company is selling on a subscription billing model. Also with the notice of penalty violation letters that they've sent out in mass this time last year to a couple thousand companies, saying that if you violate the law, now that you're on notice of it, we're going to pursue you for up to $46,500 and change per violation, which they interpret to mean every single consumer who saw that ad and then completed a purchase. So it's and a variety of other things. They've hit the books, come up with creative interpretations of the law, and are pushing those aggressively. And maybe in 2028, 2029, there's going to be a case before the Supreme Court testing their interpretation of the law, and maybe they'll lose again, 9-0. But that company that's taken that case all the way will have spent millions of dollars, and even though they may ultimately win the case, just the attorney's fees and the damage to reputation and all of that could still be really bad. So the line has definitely moved the last few years with the new commissioner, chair, and the reaction to AMG Capital.
Roger?
Yeah, so, one of the things that is interesting, any of us who have dealt with the FTC staff, the FTC staff, the job satisfaction is really, really low right now. They've got statistics that show how much it's dropped, from like 80, 90% down to 50, 60%, which is significant. And that's really because of the chair, Chair Khan, who's come in. It used to be that the FTC was very consensus driven, and Daniel could probably speak to that much more. But now with the new chair, very, very less deferential to what the FTC staff has to say. And, it's what we're seeing is you talk to FTC staff, which you typically would do as an attorney to try to resolve a dispute, and they have almost zero power to agree to anything. And so it's kind of like a line. Here's what you need to do. One of the things that's very clear now is get as much money as you can and make sure that there are individuals on every order that the FTC furnishes. And that, of course, hasn't changed very much. And the FTC, even when, I think the case Damon was talking about was Walmart, and where the FTC wanted to go after Walmart. And because of the way they're having to enforce some of their statutes, the Justice Department is utilized to go after certain types of alleged violations. Well, the Justice Department refused to do it, but the FTC did it anyway. And that's where there's this issue of whether FTC can constitutionally go in a federal court and then sue somebody under certain statutes, where they typically would have the Justice Department go in and do it for them. So it's a very reduced, staff it's almost, if you don't want to agree to the new program, then you're going to have to say no. We're happy to litigate it, and then try to deal with each of the each of the commissioners once it gets up to whether or not there's going to be a complaint, or even after a complaint has been filed. And the amount of transparency is almost, there is none anymore. So it's hard to really know why decisions are being made. And we're also finding that even when you get to the director of the consumer protection side of things, that it's 4 or 5 bullet points. They really don't want to hear what you have to say. So it's a tougher way to deal with the FTC, but it's something we have to do. And FTC is more willing to litigate, and I think that companies have to be more willing to litigate.
Yeah.
I'll just say one more thing. I think on the other side of things, I think judges are a little more apt to question the FTC's interpretations of things.
Well, and that's the disconnect between, as you were saying, Damon, that the judiciary is far more conservative, and we're seeing very expansive interpretations of the statute and rules that are not falling on great ears in the judiciary.
Yep.
Interesting. Things are upside down in a lot of ways.
Yeah.
Daniel, you mentioned in your answer that there's so many different rulemaking actions going on. We mentioned, and when we were talking about this, obviously, earlier this summer, we touched a little bit on TSR, and obviously there's endorsements and testimonials, .com disclosures. Everything's under kind of a various states review. I guess I would tweak the question to be, what's happening? What's the most important, like 2 or 3 things that are happening right now? Obviously, as things move forward, that would shift, but what's happening right now?
So I would say, look, big picture, the FTC is starting to act like a mini legislature, and we certainly heard Commissioner Christine Wilson talking about that the grant of authority that Congress gave the FTC, they can engage in rulemaking on deceptive and unfair practices. Supreme Court just had a really big decision a couple months ago questioning sort of the scope of what rulemakings agencies can and cannot do. Despite the issues raised by the majority in the Supreme Court, the FTC is going full force with a number of rulemakings that I think would fall likely within the ambit of the Supreme Court decision. Most notably, they're doing the rulemaking on what they call commercial surveillance and data security, or what we would call privacy. It's interesting, they're doing a rulemaking on privacy. They aren't even using the word privacy in the rulemaking. It's actually, literally, I did a search for it. I think it came up like twice, and they had no choice but to use the word privacy. But they've reframed the argument. I mean, that's what they're doing a lot of. It's no longer about sort of privacy and issues like that. It is, we're going to sort of tarnish how data is being used to advertise to people by calling it commercial surveillance. And it's an effective strategy. And we see members of Congress are starting to use the terminology also. So that rulemaking they're doing, it's from my perspective, it's going to last forever. It's overly complex. It's hitting too many issues. But it's really important to look at that and watch what the FTC is doing, because that is what Chair Khan cares about. She cares about how data is being used, what's being done with it. And there's a lot of emphasis there on that. And the second thing, the one I mentioned just before on the junk fees rulemaking, I mean, I think ordinarily, when you look at fees that are charged in transactions, we've always known the FTC's focus, how is it being disclosed? I mean, generally not much care about what is in the fee as long as it's being adequately and accurately conveyed to consumers, that you're going to have this fee, this is what it's for. Now they're questioning the merits of what that fee is. So, top of the list, of course, is resort fees for hotels. That comes across very clear. Different fees you get for sort of Ticketmaster and companies like that. But it goes beyond that. They're going to start looking at fees in this rulemaking, and are the fees adding value to consumers? And for an agency to sort of put themselves in that role is very difficult to sort of do that subjective assessment. So, the rulemakings are, look, they're not fun and exciting to look at rulemakings, but they give you the clear path of what do they care about, what are they looking at, and what's the different focus here. And we haven't seen this level of rulemaking since the 70s. It ended disastrously for the FTC back then when Congress shut them down for a few days. So we will see what happens here.
Yeah. Damon.
Another area where there's been a real strong enforcement initiative is with businesses that are focused on money-making opportunities. And so that could be, classic example would be multi-level marketing, but it also could include business coaching, or make money, an offer to make money being an affiliate marketer, or make money with an Amazon store, or even financial publishing that's been around for centuries, as long as there have been markets. And the FTC is going to issue an earnings claims rule at some point that was published for comment back in the spring. But it's I think a real concern because I just outlined a few different types of business models. It's not one size fits all though. If a financial publisher is good at coming up with trade alerts and has a positive track record of trade alerts that make money, maybe over a 2-year span, it's a win rate of 65% and an average return across winners and losers of say 12%. The FTC's position is you can't say that the guru can't say, and I'm confident that's going to continue into the future, because now you're making a future earnings claim and you can't predict with any kind of certainty or clarity because you don't have a crystal ball. But it's a weird thing because people who are good at what they do should be able to say they're good at what they do. If I'm a fitness trainer and I help people lose weight and someone comes into my gym, I can say, yeah, I think I can help you lose weight. The FTC is now viewing that as potentially a deceptive earnings claim, or a different scenario, but in the context of financial publishing, a deceptive earnings claim if they make those kinds of claims. And it's frustrating because with the markets, for instance, people know they go up, they go down, Russia invades Ukraine, China does this, the administration does that, it changes all the time. But that's an area that's, you'd like for the FTC to look at this from a business perspective and a real world common sense perspective, and I'm concerned they're not. And there's also a lot of First Amendment issues in play with non-commercial speech and commercial speech. And they have lost from time to time when they've overstepped and overreached and in a way that's contrary to the First Amendment. So, but anyone that's in a sort of a business opportunity, business coaching, business really needs to take a hard look at their ad copy, their testimonials, their claims about past performance, and what they're saying about the future. Because right now there are companies that thought they were doing things right, were smart, did have good in-house counsel, but the FTC's position is they've crossed the line. And for every one of those companies, there are many, many others who are doing things not quite so well, and they're all, of course, very vulnerable too.
Yeah, well, one of the things that has, and you mentioned it, Daniel, about the junk fees, and there's also a bait and switch, and there's a real focus on more disclosures in every ad. And originally, this was focused on automotive fees, right? You see a lot of that. If you bought a car recently, you'll see all the extra fees that try to go in there. They try to put in there that seem to be nonsense. Why are you paying an extra $2,000? What's the value there? But when you look at it from that context and then you apply it to what we're doing in this space, right? Then every fee that is charged, and you think about it in terms of just pay additional shipping and handling, right? Remember, what's that guy's name? Who used to sue everybody saying that, hey, well, it's additional shipping and handling, but you get the second one free, but it comes in the same box. It's already prepackaged. So what's the additional shipping and handling? What did it actually cost you? That's where the FTC is now on these additional fees, or the idea that you haven't disclosed what the additional value is with the fees, or that you haven't disclosed more specifically what the additional cost is, right? And so I think that's where you're going to see it as applied in this space, in addition to things Daniel and Damon said.
Yeah. Excellent. One of the areas, obviously, that's been a focus and is ongoing, seems like forever. I've been doing this for 20 years and hosting these panels for 20 years. Endorsements and testimonials. It just kind of shifts like where they're looking at it. Obviously now, online reviews is a huge factor here. Damon, can you give us kind of the latest hot buttons in this online review space and where they're looking at and where marketers have to take the most care?
Sure. Maybe everyone already knows sort of where we are up to this point, but with the endorsement and testimonial guidelines, the position, the law has been for quite some time that an advertiser cannot make a claim through a testimonial that they could not make directly themselves. The person who provides a testimonial must be an actual user of the product or service. That's sort of common sense. And there has to be a disclosure of any material connection between the advertiser and the person who's provided this testimonial or review or endorsement. If there is a material connection means was the person providing the testimonial, the review, the endorsement, were they compensated in some way, even with free product, or did they have some connection to the company, close friend or relative of someone at the company? So could they perhaps be biased? And there are ways to make that disclosure that don't have to sound like legalese. We gave some of our favorite people free product, and here's what they said. If you can write the copy in an upbeat sounding way, it can actually help conversion and not look like something that people should worry about, that's a biased review. But in any event, over the last year, the FTC has focused a lot more on this, and when I was talking before about notice of penalties letters, they sent out letters to, I think, 1,100 companies back in the fall of 2021 saying, we're putting you on notice that there is this body of law concerning endorsement testimonials reviews, and if you violate this area of law, again, we're going to pursue you for up to $46,500 in penalties. And it's really like a who's who of every single major brand that sells anything, direct or not direct to consumer. It's 1,100 letters. It's hard to imagine that there was more than maybe 20, 30 minutes of thought before they added someone to that list and sent that letter, just given the number of companies they sent it to. And the letters weren't specific. This is the particular ad copy we're concerned about. It was a form letter. So they could have gone through the entire Chamber of Commerce perhaps and looked at every single company and sent it to 100,000 companies. But it's another way they're trying to circumvent the result in AMG Capital. How do we get money? So there's been that activity. Earlier this year, there was a case against Fashion Nova, who incidentally had an earlier case a few years ago relating to, I think it was gift cards.
Mail order violation.
Oh, that's right, mail order, right. Delayed shipping, that's right. But Fashion Nova entered into a settlement with the FTC having to do with curated reviews. And so Fashion Nova had on their website a place where consumers could post a review, 1 star, 2 star, 3, 4, 5 stars. And then after collecting those reviews, Fashion Nova would only display on their website the 4 and 5 star reviews. And so they paid a few $1 million, I think in maybe disgorgement or penalties, I can't recall right now, but to settle that case and agreed that they would no longer do that. And the FTC has said that violates our guidelines to suppress negative reviews. If it's on a social media platform and it's in the past, and you've maybe done things in the past that where it's a little more passive, it's not your own website, the FTC is not taking quite the same approach as opposed to your own website, of course, but that's been a major development. And then the FTC is also going to issue updates to the endorsement testimonial guidelines where they're going to get much more granular about fake reviews, about liability, intermediary liability for advertising agencies that knew or should have known that the advertising content or their testimonials reviews were deceptive. And most recently, and I've seen this from a couple of cases I've been involved in, the FTC is starting to try to argue that it's deceptive to use a testimonial that is not typical of the typical consumer's experience, which is completely outrageous to me. For a long time, a dietary supplement, a weight loss offer would say before and after, 10 pounds in 3 weeks. But there's hopefully a conspicuous disclosure of what is typical. Well, now those testimonials, if the FTC continues down this path, those would be considered deceptive. So the ad would have to say, Susie lost 2 pounds in 4 months. It's not going to have the same effect. And it's just not, I think it does, again, go back to free speech, First Amendment issues, and really kind of assuming that if you're marketing a product and you're making money, then you're probably doing things the wrong way, and sort of take the fun out of marketing. People should be able to boast about their success stories, but at the same time explain what is typical. And so hopefully we'll be able to push back against that effort, but it's concerning. Jared probably was not the best spokesperson looking back, but it was interesting to hear his story, right?
Roger.
Yeah, so with their updates to the new endorsement guidelines, the FTC has expanded the definition of endorser to be computer-generated influencers, right? Something totally made up by someone. The other thing, that is also covered under the new guidelines, or updated guidelines, is tagging a brand or tagging a brand in a social media post is expressly considered to be an endorsement. And so if you think about it from the standpoint of either a company or someone else tagging, saying, oh yeah, great, I'm tagging this. So now you have somebody else who has to make a disclosure, whether they may know it or not. And then finally, they updated the definition of clear and conspicuous to be difficult to miss and easily understood by quote unquote ordinary people. So a lot of room there for the FTC to decide who the ordinary people are. So there's a lot going on with the endorsement space now, and it used to be pretty easy to comply. Now not only do you have to make clear that you're an influencer or endorser, you're getting some benefit from it, but you also have to make additional disclosures.
Yeah, so I think the one thing we might not have mentioned, unless I totally missed it, they also kicked off a new rulemaking last week, specifically on reviews and endorsements. So again, the FTC does rulemaking because they want rules in place which allow them to then get civil penalties, very large, and potential redress back to consumers. So again, another emphasis on reviews. And to be clear, it's not just about how you are posting the reviews. Are you suppressing the bad reviews? Also, how are you collecting them? Like, are you encouraging only satisfied customers to post reviews? That is a violation, according to the FTC, of the FTC Act. If you're sort of skewing how you're soliciting reviews to your satisfied customers. If you're sort of intervening on behalf of the negative customers to discourage them from posting, that can also be an issue. So the FTC is really looking at all aspects of the review process. They're also, it's interesting, the meeting last week, they had a public meeting on this rulemaking, really cynical also about platforms. I was actually kind of surprised. They seem to attribute a lot of bad intent to sort of third-party platforms that are sort of posting and hosting reviews, that they have a financial incentive to only post good reviews and not post bad reviews. So I was a little surprised about that. I'm not quite sure if large platforms really have that incentive. They want people coming back to make future purchases, and if there are bad reviews that should be there, they should be there. So it's
yeah, there's one review site they like, right?
Wait, which one?
The Better Business Bureau.
Oh, yes, yes, of course.
I don't know if that's a review site.
I was going to say, I never think of it as a review site.
Well,
but,
that's good. There's a place for reviews and complaints. I've never really understood the distinction between the two. They both usually say...
If you've got a D or an F rating, that's not going to go over well. Right, I can tell you that.
Well, obviously, very busy. Very, very busy. And to Roger's point, if morale's low and they're so busy, are there any other areas where they could possibly be extending efforts in the next 6 months, Daniel? I mean, is there where else could they go at this point?
So I have my two rulemaking predictions. Mm-hmm. So this year they are supposed to review the green guides. So again, guides are not rules, but the guides tell marketers, what do we think violates the FTC
Mm-hmm.
Act? Green guides have been in effect for quite a while. They're up for review. So they're going to review the green guides. What does recyclable mean? What does it mean to be carbon neutral, compostable, all those terms. Mm-hmm. It's actually a helpful guide. But there's also a lot that's not in there. They sort of kick the can on sustainable. They're like, yeah, we're not going to deal with that. They're going to have to deal with terms like sustainable now. They're a lot more important. So I'm actually thinking that they could also do a green rulemaking. Mm-hmm. So one of the challenges at the FTC, a lot of things like green claims, how do you monetize it? How do you sort of figure out how much money a company should pay if they've sort of violated it? So a rule in the green area, I think, could be coming. Mm-hmm. Again, I don't have any inside information, I swear, but I just think it makes sense. If you're going to do the guide review, they're probably going to start some sort of green rulemaking. The other thing, I know we're going to talk more about dark patterns. Mm-hmm. They're addressing dark patterns in a lot of different contexts. It comes up in their privacy rulemaking, but it's just such a pervasive theme at the FTC right now that I do think we could see a dark patterns rulemaking sort of in isolation. Again, if you've got 6 rulemakings going on, why not have 37? That at this point, sort of just kick off a lot more and see what happens.
Yeah. Damon, Roger, any thoughts on any predictions?
I know they're updating their guides some, so I don't know if those turn into rulemaking. And one of the commentaries is that it's pretty easy to do rulemaking and under this administration and how Chair Khan is acting on it. And so there's a question about whether these are too hasty to make these rules, where typically they've been more, they spend a lot more time thinking about getting more comments about it and trying to incorporate comments from those who provide them. And now it appears that, they're going through the motions, but this is pretty hasty rulemaking on a lot of areas very fast. And so, if the guides are any prediction, you've got a guide on deceptive pricing. They're going to update guides on bait advertising, right? It's always the clickbait we're talking about, and use of the word free, right? So all those things exist, but now they're updating them all, and next thing you know, we'll have rulemaking on it. So.
Two areas in terms of enforcement. I think they are showing more and more that they really want to go after companies that they view as recidivists, and there perhaps used to be a sense of, okay, we've settled with the FTC, and now we have a little bit of a honeymoon period, and we will comply with this consent order, and they'll move on. But more and more, I think the FTC is really watching a company like a hawk and wanting to issue a press release that says, we go after recidivists. Don't think that this was a get-out-of-jail-free card because you just finished a settlement. So that's concerning, because sometimes when they do that, they pursue an investigation so thoroughly for so long that regardless of the evidence, they are going to try to come up with something to say, to complete the narrative they want to. So I think there's been more of that. And then one area that they just also seem to be really adamant and zealous about is Made in USA claims. And that's been around for a while, the requirement that if you say Made in USA, all or virtually all of the ingredients or the components of a product actually have to be sourced from the US. It's not a common sense definition. If I have sushi downstairs at Nobu and the meal is on my plate, I think this meal was made in the USA. But if the salmon came from Asia, no, according to the FTC, that would not be made in the USA. And a lot of, not people in this room, but a lot of ordinary people who are trying to launch a business think, oh, of course this is made in the USA. My manufacturer is in the US. So I think that's going to become a bigger and bigger enforcement issue or priority for the FTC. And I think, frankly, I think the definition should be revised to comport with common sense.
Actually, it's funny, Damon, you mentioned press releases, and actually,
yeah.
This is just, it's sort of a small thing, but the press releases have grown in sort of craziness. Like, every press release is talking about, no matter what the violation, the company lied, cheated, stole. And actually, recently, one company actually fought back and went to federal court and said, what's going on here? This is, and the FTC actually changed its press release. They took out the word lied. Right. And
that was a Made in USA case, wasn't it?
Yes, it was a Made in USA case. And it's interesting. I mean, companies are starting to sort of push back, not just the big companies, but some smaller companies also. But the press release one was interesting. I was surprised the FTC sort of caved on that, but they did. That's a big deal.
But if you think about it, if the FTC is really, really committed to helping businesses and consumers, they should play it straight. When they issue a press release or when they file a complaint, they should lay out the facts in a fairly objective way, a balanced way. That informs businesses about what they need to do to comply, and that ultimately helps consumers. But so often, they make the company out to be the second coming of Attila the Hun, public enemy number one. So I guess they can feel like they're superheroes or something like that. But it doesn't help the public. If you're really committed to your mission, play it straight. Say the company did some things well, but they made a few mistakes here, and therefore this is what they're doing, as opposed to saying they're just totally corrupt.
Right.
It's really frustrating. It doesn't serve their mission.
But if you think about it, what the FTC is doing by going over the top on the press release, other companies looking at it and say, well, that's not us.
Right.
We don't do that.
Exactly.
And so they don't think anything about it. Well, we're not going to do that. But in reality, it might have been a very small thing that the FTC grabbed onto and said, we're going to force you to spend millions of dollars or a lot of money to fight this, or you can agree. And that's kind of another thing the FTC has hung on to forever. They will not allow somebody in a consent judgment to say they deny the facts, right? They want you to say, I neither admit nor deny.
But then
And so
sometimes
it's-
they'll try to, I'm sorry.
Yeah, and to the points we've been making about the press release, they always make it sound like somebody has been caught doing something as if it's a judgment where there's been an admission of everything that's in the complaint. And if you read it very closely, you can see, well, this is what the complaint alleges, but that's not how the press release typically reads. And so it's very, for an agency that is out there trying to prevent deception, they are the #1 violators, right, when it comes to the press release.
Yeah. One thing they'll try to do sometimes is with the consent orders, the defendants do not admit or deny liability, but part of the consent order will be, and you have to give a notice to your customers. And here's the notice we want you to send. Well, that notice says we will no longer do this, that, the other thing. Is, if I issue notice, I will no longer commit murder. That doesn't make me look very good. Even if I wasn't convicted, I denied it. So it's frustrating, and it's hard as lawyers because we say, okay, there's this case and there's this. Here's what the FTC is saying, and clients will read those complaints and say, are you sure about this? Because that company was really, really bad.
Yeah, the notices are becoming punitive, and the FTC does not have penalty authority in a lot of those areas. And you look at these notices, and they're not designed to sort of give consumers helpful information. You've been overcharged, you had a breach, check your sort of credit score. I get those, but now it's just like
Rub your nose in it.
Exactly.
Yeah.
Exactly.
Yeah. You tell them we really love the FTC.
I was there for 23 years. It was different then, I swear. There's a reason I left. That's for another panel.
An extended panel.
Yes.
We'll do a one-on-one someday.
Therapy, yeah.
Dan, you mentioned dark patterns. Of course, we're going to get into dark patterns. I'm going to go to Roger first with this. We've talked about dark patterns on this stage last year in Miami in spring on various webinars, but some folks here still might not know what that means. Roger, can you give us a quick descriptor of what the term means, and then an update where things stand today with dark patterns?
So I'm gonna read you some definitions. Well, first, where it came from. It came from user experience expert, right? A guy named Haire Brignall. That's the furthest back somebody can find it. It basically defined it as a user interface carefully crafted to trick users into doing things they may not otherwise do, such as buying insurance with their purchase or signing up for recurring bills. And these things are not mistakes. They're carefully crafted with a solid understanding of human psychology. They do not have the user's interests in mind. In reality, this is really, the FTC might say it's a subset of deceptive advertising. But you will see things that they might allege previously as being a violation of Section 5 of the FTC Act because it's deceptive, but now they're calling it dark patterns. And it's almost as if, I think it is, that the FTC is using the word dark patterns, so just as they do with many things, they want to encompass as much as they can into one violation, if you will. And if you look at some of the cases, some of the things that come out, it's deceptive system designed on websites and apps that prey on human cognitive processing frailties, right? Deceptive design choices that take advantage of behavioral tendencies and manipulate users to make choices for the designer's benefit. Now, some of this might be legitimate, right? You might have, when you look at ROSCA, do you have a pre-check box? It's actually not a violation of the law to have a pre-check box, but it's not good practice because you're going to get a visit from some regulator, and you still have to have express informed consent in a manner that's clear. So it often doesn't make sense to have the box pre-checked, but in theory and technically it's not a violation, right? So if we look at some cases, right? So there's a case where a company called Roomster advertised it had millions of authentic and verified listings, but in fact failed to verify listings or ensure their authenticity. And so after people would pay an access fee to look at these listings, they found that a lot of them were bogus. And so what Roomster also did was purchase 20,000 fake reviews, and then they would kind of drip them in over time, and so they got to a point where they became #1, right? because of these additional fake reviews higher than anybody else, and then, oh, the highlighted person on or company on Amazon for a product, whatever it might be, people are going there. Well, those can be real things, but this is an example of what they consider to be a dark pattern. Another case where was filed against Intuit, alleging that the company's marketing of TurboTax as a free tax filing service misleads consumers because the free service applies only to some, right? So it's kind of a lack of full disclosure, right? When you're saying it's a tax-free service. I mean, I don't think most people think that, oh, no matter what my tax situation is, it's going to be free, no matter how complicated it is. But this is one where they felt that it was considered to be a dark pattern, use of the word free. So there's another one where a complaint against a credit service company, Credit Karma, for allegedly deploying dark patterns and misrepresent that consumers were pre-approved for credit card offers when in reality almost a third were denied. So so they went back. So part of the investigation was, how do they prove that nearly a third were denied? Well, a civil investigative demand comes out. They go back and find that Credit Karma's doing A/B testing, and they're finding out that, well, if they're pre-approved, they had a higher success rate than not saying pre-approved with the A/B testing. So, I mean, there's some legitimacy to it, but by the same token, it's considered a dark pattern. So almost anything can be a dark pattern, and there are, example after example. So,
Thank you. Damon.
Yeah, so a lot of the things that Roger's described would be considered violations of Section 5 of the FTC Act, is deceptive advertising. I think because, though, the FTC has this laundry list of things that they consider dark patterns, there are things that are being included there that aren't necessarily violations of Section 5. So it could be a countdown clock. In and of itself, the FTC historically would never take action because a company has a countdown clock on their website. But now that's going to be, I think, something thrown in if it's a countdown clock and when time expires, you aren't kicked off the site. If it's a countdown clock and time expires and you are kicked off the site, the FTC still wouldn't like it because they'd say, why are you wasting time with a countdown clock? Why are you kicking people off the site? But it would not be deceptive because if you're kicked off the site, the timer obviously meant something. Similarly, saying, today we're going to offer this product for 25% off. The FTC would say that could be a dark pattern. Even if that's true, if the next day you offered it for 30% off, or the day after you offered it for 20% off, in their minds, that's a dark pattern because you're just discounting the price to get people to buy, to trick people. Or on the site to have a flashing red arrow next to the one pricing option you want people to actually select, right? They would say that flashing red arrow is another dark pattern. So there are a variety of different things that people have used to draw attention and get people excited, to create a sense of urgency. And even in some instances where they're not truly deceptive because they actually are true, the pricing discount or the countdown clock, the FTC is still going to lump them in as dark patterns. And there are many other examples of that kind of thing. And that's where we're seeing a lot more kind of overreach.
Yeah, the FTC came out with a report a few weeks ago. They did a workshop on dark patterns about a year ago when I was there. Came out with a report that really didn't shed much light on, it talks a lot about different things that can be dark patterns, but I don't care what's a dark pattern. I care what is a dark pattern that violates the FTC Act.
Exactly.
And that's the disconnect here. Lots of stuff can be dark patterns. One example is what they call confirm shaming. Confirm shaming, where you go to a website, do you want to buy insurance? Yes, no, and if you click no, it says, what do you mean you don't care about your money? That's confirm shaming. That's considered a dark pattern. Do I think it's an FTC Act violation? Probably no. Do I think it's advisable to do that now? No. So it's really that parameter of what is and isn't. But a lot of the focus is also on parity of choices on a website. So do you want this yes, no? Yes, no buttons must be sort of equal size. That's a big issue, and there's a lot of European documents out there also on what they're expecting on dark patterns. So it's, again, I would love more clarity, not in the form of rulemaking, but I think we might get one on what is and isn't an actionable dark pattern.
Right, right.
Basically, the most typical, creating a sense of urgency is now considered a dark pattern, right? I mean, that's what every commercial, every commercial has done since the beginning of DRTV, right?
Now supplies are limited. Supplies are always limited, but
right, yeah. And so you're seeing these things that are have been generally okay advertising, but now is considered a dark pattern, and it's very hard to know what the FTC is going to go after next when they say, well, we think it's unfair to consumers, and you start to think, all right. What's the are they going to the lowest common denominator, which is pretty low? Or are they back to this quote unquote ordinary consumer, right? Or the reasonable person? I mean, what's the standard that they're looking at when they're thinking about a dark pattern? And you can go crazy looking at things that they might consider to be a dark pattern, but it's advertising that's been out there forever. You can't coerce somebody to want to buy a product. You can't make it look too good, right? And it's an amazing thing. The sales funnel is too long. You're taking up too much of somebody's time. The timer is misleading because it looks like you're gathering data. Whatever it is, the FTC doesn't like it. They don't want to take into account the idea that somebody is actually getting some information throughout a longer sales funnel than a shorter sales funnel. So it's more, if you're trying to get somebody to buy something through advertising, that could be a dark pattern.
Right.
You think, really,
Yeah.
right? Is there any limit on it?
it's a horrible term too, by the way.
Yeah,
It is.
Well, the term itself is, I find, completely entertaining.
Yep.
I think I've said this before. It sounds like the name of a new spin-off of like Stranger Things or something.
Exactly.
Yeah, it's made to sound that way.
Black Mirror.
Yeah, exactly.
Yeah.
We're going to skip ahead a few questions here because we are running tight on time. We've talked a lot about the FTC and the federal government. I'm going to throw it out to the group, whoever wants to take it. Hot buttons out there where state lawmakers or state attorney generals are taking the lead in a regulatory area affecting performance markers, and also possibly in the class action bar.
So I know one class action issue that we're starting to see a lot of is the use of wiretapping laws to bring class actions, particularly on websites that have chat functionality. Very often that chat functionality is taken care of by a third party. So there are class actions being brought that by sharing that information with a third-party service provider who's monitoring the chatbot, you violated wiretapping laws. So that is a big deal right now. So if you've got a chat functionality on your website, you might want to take a close look at that because there are lots of class actions coming up in this area. Also, just green issues continue to be really quite a big deal. Greenwashing, sustainability. Make sure if you're making green claims that they're specific. You never want to just say we're green, we're eco-friendly. Eco-friendly, why? You always want to make sure you're doing that because we're seeing a lot of class actions, certainly in that space.
Right.
Yeah, another area that's been a hotbed of class action activity for quite some time has been the website accessibility area, and it's not an area where there's a lot of legal advice to provide, but it's important if you've got a website that consumers are going to make sure that you've got a very good plugin at a minimum that allows for website accessibility, or that you've gone above and beyond that and had your website code and a plugin along with a very thorough comprehensive audit from a technical consultant. When we get these cases, they typically settle for $7,000 to $50,000 depending on revenues of our client. And depending on the plaintiff's counsel, of course, but that's just continuing and making a lot of plaintiffs' lawyers a lot of money.
Yeah, it's interesting you use that as an example because you start thinking about what's the next thing that the FTC is going to focus on, and interestingly enough, I think it often comes from class action plaintiffs, right? Remember when we used to talk about Harold Hoffman was the guy's name who would go after companies when they'd say, just pay additional shipping and handling. And he would sue the company just because he thought, well, it can't be that much more additional shipping and handling if it comes in the same box. Well, now that's a dark pattern, right? And same with with the class action, when you have what you were just talking about, Damon, and that's the next thing the FTC's focused on. So you kind of start seeing where the plaintiff's bar is, and you see the companies coming after it.
Right.
And I think that's the same with AGs, right? They often take the lead. They did that back in the affiliate marketing days when the first, I think it was the Florida AG who first started going after affiliate marketers. When all of us realized, well, it's just going to be a matter of time with a lot of these deceptive affiliate marketing ads until somebody made a poster child of affiliate marketing. But it was the Florida AG that started that, not the FTC.
Great. I have one question left, but I'm going to throw it out to the audience before we go to that last question and see if there's anything from you all out there. Right there.
Yes. What liability does the media outlet have for distributing content that the FCC finds as in violation? Cheers.
Anyone?
So generally, the FTC has not gone after media outlets. They do a lot of sort of browbeating and trying to encourage media outlets to screen better. They had a big campaign about 10 years ago, no longer than that, on weight loss issues. But generally speaking, unless the media outlet's involved with the creation of the content, some real First Amendment issues. So they've been steering clear of that generally.
Jennifer?
No.
Yeah, definitely.
Well, unless there already is a CID out there, in which case they shouldn't be destroying evidence. But that's always a question, and it depends on what they're doing the A/B testing for. Also, sometimes a lot of A/B testing can be used to defend a client when it's legitimate A/B testing, and it's not, should I do it with and without a checkbox, right? Or should I do it to see generally what's going to drive more revenue, more conversions, even though you know that, well, I really probably shouldn't do it on the A way I've been doing it. So I mean, if you're counseling clients, you need to see what the purpose is. If they just happen to do it, I mean, it's not a good thing if they're doing it for the wrong reason.
Thank you. I think a lot of us here probably rely to some degree on larger platforms that you might have indirectly mentioned earlier, like Amazon or Google or Meta, for advertising, customer acquisition. I thought there had been a lot of scrutiny by the FTC on larger platforms, preventing acquisitions, threatening to break those companies up. Could you maybe update us on the status of those investigations or those policies? Thanks.
So I'm not a competition lawyer, but the FTC is very actively focused on tech companies. They're in active litigation with Meta on the acquisition of a virtual game app. So that's an active litigation that's going on. There are lots of reports that there's a large Amazon investigation at the FTC that's pending. But I mean, this is Alina Khan's mantra. I mean, she did a lot of writing and has written a lot about concentration in the tech industry. And if there's one thing that she's expected to do in her tenure, it's to bring massive cases challenging tech acquisitions. And we're starting to see some of that.
And Daniel, correct me if I'm wrong, but with those platforms, there should be a good Communications Decency Act defense.
Yes.
That they are an interactive computer service provider, and therefore, under the Communications Decency Act, Section 230, they're not liable for content provided by another. In the same way that the posts on Twitter, Twitter is immunized from liability, or even Ripoff Report, consumer gripe site, immunized from liability for content posted by another. But that Communications Decency Act, for political reasons and a lot of other reasons, is under attack.
Well, my last question to each of you. If you could select one thing for our attendees to take away from today's conversation, what would it be and why? I'll start with you, Roger, at the end there.
Okay. Well, I mean, given everything you've heard here today, one thing that I think you really need to think about if you're the advertiser or the platform or whatever it might be, you've got to look and make sure that you're trying to comply, right, with what you know the rules to be. Obviously, get counsel, but if you think about disclosures, if you think about even the idea of a dark pattern, are you deceiving somebody or not deceiving somebody? Forget about whether it's the lowest common denominator, but if you're hiding something, if you're expecting people to have to click on a link to understand what the offer really is, or what the product is, or what the product can do, then you shouldn't be doing that. And it's the best way to avoid scrutiny by any of the regulators, particularly the FTC, is to try to follow the guidelines, right? They're available to everybody at ftc.gov. Obviously, plenty of lawyers floating around here. I'm sure all would be happy to help you in terms of advertising. But it's important to understand what you're selling and what you're doing to sell. And so, with the question with the A/B testing, obviously trying to follow the right path, but you also don't want to leave that evidence sitting around. The FTC has and will continue to misuse it in a way, and it's the rarity that you can actually use that to defend, but it can happen sometimes.
So the test for advertising is not whether something is just literally true, but it's is it misleading? And the FTC has kind of a jaundiced view sometimes. They think consumers are very ignorant, and so they say the overall net impression of this advertising copy, these claims, is deceptive, is misleading. That doesn't necessarily make it so. The FTC could be viewing things through sort of a jaundiced perspective. This is in view of that, and kind of going back to your point about A/B testing, something that companies should consider more and more, I think, is doing their own consumer survey with a reliable, well-respected consumer survey expert to establish what is the net impression from this ad, what is the net impression from this checkout page, and that evidence. I was on a call with the FTC yesterday, and the attorney there said, "I know marketers never want to do consumer surveys, and I get that." And I said, "No, I'm not sure that's true. I think we would be inclined to do that." And I don't believe your perception of net impression is really what the net impression is. So consider using a consumer survey expert to do a test, and do it on the front end. And it's kind of an insurance policy. When the FTC shows up, you can say, okay, we hear you about what you think the net impression is, but this is a survey of 150 people, and here's the takeaway they had from this. That can short circuit the conversation. I used to work at the firm Rogers at Venable, and we had a matter with the Florida Attorney General, and they told us again and again what they thought the net impression was of our checkout page, and how consumers wouldn't realize that this was a subscription billing model. And we had a survey done, and survey expert Hal Port came back and supported that 90% of people knew this was a subscription billing offer. The Florida Attorney General never contacted us again after that. And so think about doing that. And I think that can be, again, a good insurance policy.
So I would say two things, if you can give me the creed. Disclosures. Look at the disclosures on your website. If they look like they were written by lawyers, you have a problem. Less is more. You don't want jumbled up legalese. You want it to be clear, conspicuous, and actually comprehensible. Again, not lawyer written. So just take a look at your disclosures. Make sure the information is understandable, because there is a tendency to put too much information in there. As soon as you're more than 3 lines, it's incomprehensible. So look at that. Second thing is, I was doing a review of a website the other day, and they had a study. It was perfectly fine to make certain claims, but then they were making claims that I don't know who created the claims, but they didn't understand like math and extrapolation, and just really look closely and try to stick to the claims that you can support. And if you're going beyond that, make sure you sort of understand the parameters of it. It was sort of surprising to see the claims that were on this website because they were somehow deriving from this study and the math was just off. And that would be an easy lawsuit. And also the claims were preposterous, like they just didn't make sense also. So just math has to be your friend in some respects when you're looking at studies, and make sure your claims are meeting the available evidence that you have, because there's just a tendency to push it a little too far.
Great. Well, how about a round of applause for Roger, Damon, Daniel for their efforts today. Thank you guys. We appreciate you being here. We appreciate you taking part. Next on stage here at 1 o'clock in about an hour, the PDMI's Workshop Council presents how the QR code is changing media attribution. Should be a great panel, don't miss it. And tonight at 5:30, join us at Float on the 4th floor, their rooftop lounge here at the Hard Rock for the Sundown Shindig presented by Extreme Reach. It's the first of our 2 big all-access parties this week. So we'll see you there, and we'll see you at 1 o'clock. Thanks, take care.